Good morning, everybody. My name is Tommaso Virgili. I'm a postdoctoral researcher at the Virgili Social Science Center. And in this video, I would like to tell you a little bit about my book, published by Routledge and entitled Islam, Constitutional Law and Human Rights, Sexual Minorities and Free Thinkers in Egypt and Tunisia. First, however, I would like to thank my friend and mentor, Professor Giuseppe Martinico, as well as Diritti Comparati for giving me this opportunity. So in this book, I wanted to explore how the legal reference to Islam and its rules and principles affect individual liberties. The analysis of constitutional texts is especially interesting from this perspective. My book follows a trajectory from general to particular. I begin with a general assessment on the concepts of constitutionalism and human rights from an Islamic perspective. I then zoom in ratione loci on Egypt and Tunisia. And finally, I circumscribe the investigation by focusing on the situation of LGBT people and free thinkers in those countries. I've based my assessment on literature, legal text, and case law, of course, but also on interviews that I conducted in Egypt and Tunisia. These interviews involved legal actors, activists, academics, and victims of human rights abuses. So, first of all, in this book, I show that Islamic law, as traditionally interpreted by the dominant Orthodox scholars, presents areas that are significantly problematic from the perspective of individual freedoms. And for this reason, the reference to Sharia, or even to Islam in the constitutions, created tension with modern rights as descending from the secular tradition of liberalism, and also as they are enshrined in the constitutional law and international law. This tension manifests itself more acutely in certain domains. I'm thinking of equality between Muslims and non-Muslims, equality between men and women, prohibition of torture with reference to Shariatic penalties, freedom of religion, including apostasy from Islam, freedom of expression in relation to heterodox and blasphemous speech, and sexual self-determination, including homosexuality. This tension, unfortunately, is not a matter of a distant past, but is still present today. In my book, for instance, I analyze the main Islamic Charter of Rights, namely the Universal Islamic Declaration of Human Rights, the Cairo Declaration of Human Rights in Islam, the Arab Charter of Human Rights, and also the constitutional project drafted by the renowned Islamic University of Al-Azhar. And I show that the impact of Sharia makes those texts incompatible with the universal human rights system. Similar problems emerge to different degrees in the constitutions of Egypt and Tunisia. The former, in all its different iterations since 1980, has contained a Sharia supremacy clause and other religiously based provisions that have brought about legal uncertainty and human rights violations and discriminations. The Constitution of Tunisia, more secular in character, is certainly more in line with international standards, but ambiguities and legal discriminations persist due to the necessity of appeasing Islamist parties that, by the way, in the drafting phase had attempted such moves such as constitutionalizing Sharia, institutionalizing Islam as the religion of the state, prohibiting blasphemy, and replacing women's equality with complementarity with men. The analysis of my case studies confirmed this theoretical framework. I focused on the least explored and most controversial issues, such as apostasy, blasphemy, heresy, which I gather under the hat of free thinkers, and homosexuality. I call these issues the most controversial because they are radically excluded from the human rights debate in the prevalent Islamic mindset. Interestingly, but perhaps not surprisingly, legal text, case law, as well as the accounts of my interviewees, show a conceptual association between these categories, between gays and free thinkers. They are both punished under the same vague laws aimed at protecting public morals, and they are both identified in the jurisprudence as expressions of errors, deviations, even Satanism. Indeed, religious arguments recur in the judgments involving those people, and they are used to censure expressions of individual consciences, such as atheism or forms of art deemed blasphemous, homosexual behaviors, but also academic research when this academic research is perceived as heretical, and even pure expressions of personal identity, such as an effeminate appearance or the fact of belonging to unaccepted religions, such as the Baha'is, for instance. While the criminalization of these behaviors and this minority persists in Egypt and Tunisia, I argue that the constitutions of both countries, as well as international law, would require the protection of these minorities. However, a mixture of cultural, legal, and religious arguments prevent this outcome. So overall in this book, I show that Islamic constitutionalism is tainted by a fundamental contradiction. Namely, what is intended to prevail between a human-made charter and God's law, and what happens when the two collide. The impact of a religious group norm seems to be detrimental to the rule of law, and also to individual freedoms, especially those freedoms who are anathema to a powerful orthodoxy, and also to a powerful majority. As such, my view is that a religious group norm should not have any place in a constitution, whose supreme mission is not the protection of the majority and the imposition of the will of the majority, but the protection of minorities, and especially of the most vulnerable individuals, bearing in mind that individuals are the smallest minority on earth, as Ayn Rand used to say. So, this is my book in a nutshell. I hope I was successful in presenting it in broad strokes, and I thank once again Giuseppe Martinico and Diritti Comparati for inviting me here today.